Next matter to come before the court this morning is Parkview Federal Savings Bank versus Ruth Nader et al. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve any time, please let me know when you come up to the podium. I'm keeping track of the time, and we'll let you know when your 5 minutes is up. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Thank you. May it please the court, my name is Michael Ayton. I'm arguing today on behalf of the appellants Ruth Nader individually and as trustee for Almost Heaven Revocable Trust and Ruth. I'd like to reserve 4 minutes of my time for rebuttal. This matter is before the court on an appeal from a summary judgment entered by the Medina County Court of Common Pleas based on a mortgage secured by a promissory note and line of credit as subsequently modified, assumed, and guaranteed. The appellants raised 6 assignments of error. I will address each in turn. First is that the trial court erred in striking the jury demand of the defendant's appellants. This is the most straightforward and easiest of these assignments of error to address. The trial court simply got it wrong. Where there is a claim for a personal judgment, then the party is entitled to a jury. The law that was relied upon by the trial court, cited by the appellees both in the court below and herein, is simply inapposite, falls into 2 general categories. One, really it's only to claim for a deficiency judgment, or 2, essentially uses the analysis. You look to what the essential nature of the action is, and if it's a foreclosure, it's equitable and you don't get a jury for anything. The fact of the matter is the law cited by the appellants is the correct test. If there's a direct claim for a personal judgment for money damages, this is a jury issue, period. Therefore, the appellants were entitled to a jury, and the ruling should be reversed.
So this wasn't a foreclosure?
Of course, it's foreclosure.
Okay.
Was there a separate count in the complaint?
It is. It's a 2-count complaint. One is a count for money damages on the line of credit note, and the second is the claim for equitable relief in the foreclosure. Okay, on count 1, they're entitled to a jury. The law is all in the briefs, and then the court proceeds to address the equitable issues once the issue of money judgment is determined by the trier of fact, in this case the jury. The second assignment of error, the trial court erred in granting the appellee's motion to exclude all evidence existing prior to or contemporaneous with the loan assumption and modification agreements. This is essentially a textbook case for the exceptions to the parole evidence rule. First of all, there was evidence presented that the agreements themselves were procured by fraud based on Jack Mail's misrepresentations to Ruth Nader with regard to, first of all, we've alleged that the status of the payment and balances of the loans were misrepresented to Ms. Nader, and additionally, more importantly, Ms. Nader, who had essentially no direct dealings with the bank on this, as opposed to her former spouse, Ely, who had all of the dealings, was expressly told by Jack Mail that these would not be effective unless her then-spouse had the opportunity to review them and found them acceptable. Secondly, there's the issue of unconscionability. First, procedural and substantive unconscionability as set forth in deposition testimony, as well as the summary judgment opposition and the brief. The entire process was very rushed. Ruth was simply called into Jack Mail's office one day and said, "Sign this or we're foreclosing on your house." Again, she was told that this was all going to be contingent upon the approval of her husband, who was the one who had all of the knowledge on their end of these matters. And secondly, as to substantive unconscionability, as Parkview, by and through Jack Mail and its other agents were aware, Ms. Nader had income of a few $100s a week at this time. There was simply no way that the payments that were to be made under the assumption modification agreements were going to be payable by her. And this is specifically prohibited by 12 CFR 7.008B, which relates to prohibition on the extension of credit based solely or predominantly on realization of the liquidation value of the collateral, which, I mean, plainly at the time of these agreements would have been the bank's only hope of getting paid on this. Secondly, there's the issue of literal unconscionability as pertains to how these agreements relate to Eliaboud as an original obligor under the promissory note and letter of credit. As a non-signatory to these agreements, Mr. Aboud clearly cannot be bound to their terms. However, the agreements, again by their own terms, expressly hold that Eliaboud is to remain liable. You do need some kind of parole evidence just to figure out what this means. He didn't sign the mod, so he can't be held liable for any new balance, interest rate, anything else that's said. But the terms of the modifications themselves say he does remain liable. How does that work? You need to go outside the four corners of the agreement just to find out what it means. Last point is that evidence of the type that was excluded by the trial court on the appellee's motion is specifically stated to be properly considered with regard to agreements pertaining to negotiable instruments under UCC 3117, which is codified as 1303.15. I did include the official comment in its entirety in my brief just because it is so directly on point to the facts herein. To the third assignment of error, which was the denial of Ruth Nader's motion to reinstate her counterclaims. She just got a bad deal from her attorney. These were dismissed without her permission. The failure to reinstate the counterclaims is highly prejudicial to Ms. Nader because these were compulsory counterclaims. They have to be asserted here or they can't be asserted anywhere else. Finally, reinstatement of the counterclaims would not have resulted in any prejudice to any party because these were already fully litigated right up to the point of being submitted to the trier of fact. They had been pending throughout the discovery in the matter, which lasted literally for years. They had already been the subject of a summary judgment motion, which had been overruled. There simply would not have been any prejudice to the appellees by putting these issues back on the table once Ms. Nader had the opportunity to discover what her counsel had done and was able to secure new counsel for the purpose of reinstating the counterclaims. Fourth is... Yes, John.
Arguably, weren't those counterclaims dismissed because of a pending motion for summary judgment? Isn't that a tactical decision that trial counsel makes probably more times than they'd like?
No, I don't see that.
You
That
don't
would
think
have
that
been-
that's what the case was here?
Absolutely not.
So you're saying counsel just dismissed those counterclaims for no reason?
I could not venture a guess as to what would cause an attorney to take an action like this over his client's expressed wishes. I mean, that's malpractice and an ethics violation, irrespective of whether he thought there might have been some tactical merit to doing so. The fourth assignment of error is the denial of Malik Aboud's motion to join Eliaboud as an indispensable party. Because he did not execute the modification but is ostensibly bound by its terms, there was a determination of essentially what the status of the note and line of credit were subsequent to these purported assumption and modification agreements. Eliaboud is the necessary party to same. And in addition, the failure to procure Eliaboud's signature on the assumption and modification agreements was contrary to Parkview's own policies and procedures, as cited to the deposition of Ann Johnson in the brief. Finally, it should be noted that Eliud had previously been joined as an indispensable party pursuant to the appellee's motion to file an amended complaint. And so, just on the law of the case, he was an indispensable party and the motion should not have been overruled. The last two assignments of error relate to the granting of summary judgment and entry of a decree in foreclosure. First, there's the issue of satisfaction of conditions precedent. It's not disputed that the acceleration notice was never sent to Eliud. It's a clear violation of Section 21 of the mortgage. Secondly, there are all the issues I've already raised as to the enforceability of the assumption and modification agreements. And because that's at issue, the amounts due and owing on the note and line of credit are also at issue, which means that even assuming for the sake of argument that Ruth's motion to reinstate her counterclaims was properly denied, the issue of the $700,000 letter of credit being charged to the line of credit, which was in excess of the amount which had been authorized on the line of credit, necessarily puts the amount due on that at issue, even if she doesn't have an affirmative claim for relief based on that. That just goes to the balance that needs to be proved to obtain summary judgment on the instruments itself. There's
You
no
got 4
further-
minutes and 12 seconds left.
Thank you.
Good morning. May it please the court, Richard Klein with McDonough Hopkins on behalf of the appellee First National Bank, which is the successor by merger to Parkview Federal Savings Bank. At its core, this case is a simple foreclosure action. There has been a failure to pay anything on the underlying debt since 2011. Based on those defaults, the bank initiated the underlying foreclosure action. Now, 6 years later, the borrowers still own and reside in the property as a result of numerous meritless arguments and claims. We're here today, hopefully, to put an end to it. There are 6 assignments of error. Mr. Ayton had gone through those. Somewhat difficult to decipher some of the arguments that were attributed to each of the assignments of error. In fact, the facts section of appellant's brief is devoid of any references to the record. Simply a recitation of prior pleadings in this case. But I'll address them in the same order that Mr. Ayton had presented them. First is the jury trial. The appellants claim that the trial court abused its discretion in denying the jury demand. Obviously, as this court is well aware, that's more than simply just an error of judgment. It must be unreasonable, arbitrary, and unconscionable. The court was correct in denying the jury demand. A right to a jury demand does not exist in an equitable matter. That's a long-standing Ohio law. If there is a mixture of legal and equitable issues, the right of a jury trial depends on the action's primary and predominant objective. Now, there are numerous cases in my brief that address this issue, but I believe directly on point is the National City Bank versus Abdallah case. That's a 1999 case. There was a promissory note with a mortgage, just like here. After default, a complaint was filed seeking $300,000 in foreclosure. The defendants filed a counterclaim saying that there was a declaratory judgment action against the bank, that there was a modification to the promissory note. The trial court denied the right to a jury. There was an appeal. Court of Appeals upheld the trial court's denial of the jury, stating that it was still an equitable nature. This is despite the fact that a counterclaim was filed by the defendants. The court still denied them the right to a jury. That's exactly what is going on here. In this case, the overall nature is equitable. There is no right to a jury trial. This issue is also moot. The trial court granted summary judgment, so it never got to a point of trial. Also, the appellants waived their right to appeal this issue because they failed to file a motion to set aside the magistrate's order that was noted by the trial court in its order. This assignment of error should be overruled. Number 2, the appellants claim the trial court abused its discretion. Again, it's an abuse of discretion in granting First National Bank's motion to eliminate based on the parole evidence rule. Now, this case presents a textbook example of the parole evidence rule. It could actually be used to teach someone why and how the parole evidence rule works. Critical facts here: Ruth Nader and Ely Abood executed a note, credit line, and two mortgages in 1998. 10 years later, 2008, Ruth Nader individually and as the trustee signed an assumption and modification agreement. Now the trust is going to assume this as well. On both the note and the credit line, these agreements continue the obligations of Ruth Nader individually. It also reiterated what was owed on both of those documents. It also had some modifications to it. It had a reduction in the interest rate. It lowered monthly payments. Malik Abood then signed a guarantee. Same thing. On the credit line, reiteration as to the amount that is owed. Years later, in this lawsuit, Ruth Nader and Ely Abood, or Malik Abood, argue that the figures listed in these modification agreements that we signed voluntarily years ago, they're not correct. Now we want to go back to prior to 2008 and actually determine what is owed. This is exactly why we have the parole evidence rule. The rule operates to prevent a party from introducing evidence that occurred before or while the agreement is being reduced to final form. Without the parole evidence rule, every contract would be subject to collateral attack. They've also made payments on the credit line and the note after the modifications were executed. They made 40 such payments. They've waived any argument. This is in addition to the parole evidence rule. They've waived any argument to state that the amount set forth in the modification is different than the amount that's actually owed. Third, the appellants argue that the trial court, once again, abused its discretion in denying their motion for leave to reinstate counterclaims. I think it is extremely important to note that the appellants did file counterclaims in this case. They filed them in 2011. Extensive discovery took place over the course of 3 years. First National Bank filed a motion for summary judgment. And in response to that motion for summary judgment, the appellants dismissed their counterclaims in April of 2014. Then, a motion in limine, the one we've been talking about, was filed in February of 2015 and later granted later that month. Then, in April of 2015, 3 months after an adverse ruling and the motion eliminate, and a year after they voluntarily dismissed their counterclaims, now they file a motion for leave to reinstate their counterclaims. And it was obviously in response to an adverse ruling in the motion eliminate. They realized the critical nature of that. It's too late. The BAC Home Loans versus Mullins case set forth in my brief shows that leave was denied after the opposing party wins a favorable motion, which is exactly what happened here. There's no legally justifiable reason to allow the appellants to refile their counterclaims. They failed to comply with Civil Rule 13F, which would allow it if there's oversight, inadvertence, or excusable neglect. None of those occurred here, considering the fact that they had counterclaims pending for 3 years. The legal malpractice action are the actions of their prior counsel, Mr. Gold. Parties are bound by their counsel's actions, and that's in the Crawford versus Crawford case that's set forth in my brief. There's a legal malpractice action against Mr. Gold, who interesting says that he opposed having claims against First National Bank. Fourth, the appellant Malik Abood asserts that the trial court, once again, abused its discretion when denying appellant's motion to join Ely Abood as an indispensable party. Malik Abood mistakenly believes that judgment must be rendered against Ely Abood before his obligations, Malik's obligations, become due under the guarantee. And that's just not the law. The guarantee is clear, and this is a standard guarantee, and it provides that, quote, the obligations of the guarantor, in this case it's Malik Abood, hereunder are independent of the obligations of the borrower, and a separate action or actions may be brought against the guarantor whether or not an action is brought against the borrower, and whether or not the borrower is joined in any such action. Just as First National Bank may go after one, but not all of the borrowers in one action First National Bank may seek a judgment against the guarantor without first seeking a judgment against the borrower. This is typical, standard language. Malik Abood certainly has the ability to initiate an action against Eli Abood for recovery of that. There's no abuse of discretion here. Finally, appellant's fifth and sixth assignments of error, they're interrelated, and they deal with the court's granting of First National Bank's motion for summary judgment and then issuing a decree in foreclosure. It appears as though the arguments by appellants are threefold. One, that conditions preceding were not met for acceleration of the note and credit line. Two, the assumption and modification agreements are unenforceable. And three, a dispute on the amounts due and owing under the note and credit line. None of those arguments have any merit. First, the appellants seem to contend that because the letter of credit was not sent directly to Ely, the debt cannot be accelerated against Ruth and the trust. That contention is false for the exact reasons I had mentioned before, where you can go after one borrower and not all the borrowers. Notice of the default was undisputably given to Ruth Abood individually and as the trustee in October of 2010. The debt was therefore accelerated. Judgment was rendered against Ruth Abood in her personal capacity and against the trust. Judgment has not been rendered against Eli Abood. He was dismissed in this case. Again, the note and the credit line explicitly permit First National Bank to go after one but not all of the borrowers. There's certainly no error here. Second, appellants argue the assumption and modification agreements are unconscionable and commercially unreasonable. No evidence was presented whatsoever that supports that argument. The assumption and modification agreements are 1.5 pages long, whereby the trust assumed the debt, the principal was restated, the interest rate was reduced, lower monthly payments were established. Ruth Nader is an attorney. These agreements are not unconscionable. What is unconscionable is the fact that there's been no payment made to First National Bank on these debts since 2011. Third, any dispute on the amount due and owing under the note and credit line have already been addressed. That's the assumption and modification agreements already addressed them, and the parole evidence rule. Finally, the appellants failed to object to First National Bank's proposed judgment entry and decree in foreclosure that was filed on November 25th of 2015. As a result, they have waived their right to challenge that here. Despite all of appellants' briefs and motions and arguments to the contrary, the case is nothing more than a simple foreclosure action. Money was loaned, mortgages were given, were filed, standard residential mortgage lending. But no payment has been made for 6 years, and the appellants remain in the house. All First National Bank is looking for is the benefit of its bargain at this point. It's time for this long, drawn-out case to be over. Based on the reasons set forth in the record and in the appellee's brief, appellee First National Bank respectfully requests that this court deny and overrule all of the appellant's assignments of error, and that the trial court's judgment be affirmed in its entirety. Thank you.
Thank you. Attorney Aiden, you have 4 minutes and 8 seconds.
Again, same order. There is no mixture of legal and equitable issues as to count 1 of the complaint. There is no need to determine what predominates or anything. It's a claim for money damages. There's a right to a jury trial. And again, to the main case that appellees cited as to the proposition that this is how the analysis worked, the counterclaim is for a declaratory judgment. Whether or not that changes the essential nature, even if that were the pertinent inquiry, has nothing to do with the issue of whether you're entitled to a jury on a claim for money damages. And as to the magistrate's decision, the magistrate's decision was entered based upon the court's own granting of the motion for summary judgment. Accordingly, there isn't a need to specifically object to anything in the magistrate's decision because that was already decided by the court in order to preserve on appeal. That is, I'm doing this off the top of my head, City Mortgage versus Kinney, which is an 8th district case. As to the parole evidence argument, that payments were made does not constitute a waiver as to the issue of the inaccuracy of the balances, because the appellants didn't find it. The issue is when they found out. It's not that they changed their mind, it's that the facts giving rise to their becoming aware that these things that they signed were all wrong.
You're
Did not happen
suggesting that
until
they weren't
2000.
aware that those numbers were wrong when they signed those modification agreements?
They were not. How would they have been? Malibu did not deal with Parkview at all until its insistence that he guarantee Ruth Nader's payments, and the record is replete with evidence that she never dealt with Parkview. That this was all done through Ely, who had ceased to be available by this time, at which point, Parkview simply took advantage of the situation and, being unable to fix a balance any other way, decided to use the reduction clause approach. And it was not until Ely became available again, attained knowledge that had been persistently denied him based on the failure to have him sign off on the assumption and modification agreements in the first place, not sending him an acceleration notice. He had been deliberately kept in the dark. This was fraudulently concealed. When he finally became aware of it, action was promptly taken to correct it. As to the counterclaim, the notion that this being brought subsequent to any kind of favorable ruling for the appellees is a flagrantly disingenuous argument. I mean, Parkview is the party that initially moved to join Ely Abood as a party to this action, and then discovering the Pandora's box of issues that his involvement would have raised, decided to dismiss their claims against him. Proceeding then, in a related note to the motion to join. Yes, the obligations are independent. Yes, you can modify a promissory note, you can change the obligors, you can sue who you want. However, a promissory note as a negotiable instrument must be for a sum certain, meaning anyone against whom it's enforceable, it is enforceable in a certain amount. Therefore, the question of whether it's enforceable against Ely Abood must be determined, because that tells you whether you just go on the running balance subsequent to the assumption and modification agreements, or whether you actually have to look and see what the amounts owed on the note and line of credit properly were. And again, you can't determine that in the four corners of the assumption and modification agreements. They say he's bound, he can't be bound because he didn't sign.
Nat, you've reached the end of your 4 minutes. Thank you. Thank you for your presentation today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and added to